All right, well, good afternoon. It is 12:09 and this is my first time using Facebook Live and was having some technical difficulties despite my attempt to prepare for this. But welcome officially to the first episode of the Martinez Law Legal Lounge. We are going to be here every single Monday at 12 o'clock. Hopefully you have some lunch and you're ready to chat about some different real estate issues that are on your mind. And so I'm going to go ahead and introduce myself formally and the firm. I will not talk about myself for too long, but since this is our first one and many of you do not know me, I'll go ahead and belabor that a little bit, so bear with me. But as you join the live chat, if you wouldn't mind leaving a comment below just to say hi, I would love to acknowledge you and personally thank you for joining. Also, if you want to leave your contact information as well as what you do, I think that would be a great opportunity for anyone else on the chat that would like to connect and network with you or who maybe would need your service. So this is the Martinez Law Legal Lounge. Martinez Law was initiated by me in 2015, and my vision was to create a full-service real estate law firm. What I think sets us apart from many other law firms in this area is that all we do is real estate law. That means that we don't handle car crash cases, we don't handle family law, we don't fight traffic tickets. All we handle is real estate law, and we also do not handle title work. So typically when you come across someone who says, I'm a real estate attorney, they own a title company and they practice some law on the side. That is not us. We are 100% focused on the legal side of real estate. So part of my vision in creating the firm was also to educate the real estate professionals to try to keep people out of litigation, out of the court system. There's a running joke that litigation only benefits attorneys, and it's really not a joke because it's true. So I offer a lot of services. I host a lot of events to help try to educate the real estate community to try to keep people out of the litigation, out of the court system. A little bit about my team right now. Obviously, I am the managing partner of the firm. We also have another partner attorney. Her name is Tiffany Love. We have a COO, we have 2 paralegals, we have a legal assistant, and then we have a law clerk who will be graduating law school shortly, as well as a summer intern who is working on her undergraduate degree. We are looking to bring on another paralegal toward the end of the summer, so if you know of anybody who's looking, please send them our way. I would also like to give firm announcements during these chats. So I want to use these as an opportunity to keep you all updated and make sure that you're clear on the services we offer and how we can help if you ever find yourself in a situation where you need to contact an attorney. But I am very excited to announce that we have just recently launched flat fees as a way of billing for our services. So traditionally, we have offered flat fees for our transactional services. So if we needed to draft a contract or prepare a quitclaim deed, we've always charged those on a flat fee basis. But we have most recently expanded that into our litigation practice. And so we are now able to offer a flat guaranteed fee for your entire litigation matter. And that may seem like an obvious way to bill, but most of you probably know that traditionally attorneys bill based on the dreaded billable hour. And a lot of times that results in the client's interests being somewhat in conflict with the attorney's interests. So if we're using the billable hour model, I get paid more the less efficient I am and the longer I take to resolve your case. That's clearly not what the client wants. So with flat fees, both the client and the attorney are on the same page as far as let's get the best result possible and let's get that result as quickly as we possibly can. More importantly though, I think flat fees allow a client to really, number one, to budget for the litigation and decide whether it's something that they can afford or something that they want to afford. But number two, it allows them to make a much more informed decision on the front end as far as whether they want to pursue the matter in the first place. Under the billable hour model, when a client comes into my office and asks, what is my case gonna cost? My answer is, well, if we settle it in 2 hours, it'll cost you $500. If it takes us 2 years to litigate, it might cost you $30,000, who knows? And that's not a helpful answer to any client. Now we are able to offer a flat fee and guarantee that that is gonna be the fee that you will pay no matter what. So I may come to a client and say, your case is gonna cost you $12,000 if we go all the way through trial. That fee will be broken up into the different phases of litigation so that if we don't make it to trial, you're not paying for a trial. But you know on day one that if I pursue this, I could be in it for $12,000. Is that something I want to pursue? And it just makes for a much more informed client, a much better decision on whether to move forward, and happier clients at the end of the day. So we are super excited to be able to offer that to our clients, and we will be quoting those on a case-by-case basis. Every single case is different. The dynamics of every single case is different. So we will be quoting those on a case-by-case basis, but there will be flat guaranteed fees for all litigation matters moving forward, and we're very excited about that. So at this time, I'm going to go ahead and open it up for questions and answers. So if you want to go ahead and shoot your question into the comments, I would be happy to answer them. If you're going to be shy and not ask me any questions, I have some material prepared for you as well. I see some additional attendees have joined, so I'll just go ahead and say again, if you want to pop into the chat, say a quick hello, and leave your name and contact information for networking purposes, or maybe somebody in this chat needs the services that you offer, that would be wonderful. So I will keep an eye on those comments for any questions that you may have. In the meantime, I will just go ahead and address this crazy real estate market that we are in right now, which is presenting a lot of different and unique legal issues as we get into a more and more seller's market. So the first thing that I have been seeing is emphasizing to your clients that when you sign a contract to buy or sell a home, that is a binding contract. That is a legal obligation that if you don't comply with, there could be some pretty serious consequences. That probably sounds like really simple, really obvious advice to you, and it is, but I don't think it's that obvious and clear to some of your clients. Particularly in this market, I am seeing sellers list their house, get a very quick full price offer, sign with that buyer at full price, but then maybe some higher offers trickle in, or maybe some all cash offers trickle in. And all of a sudden, they don't want to honor the contract they just signed. They want to go after those higher offers. Well, legally you can't, and sellers need to understand that from the beginning before they enter into a contract. And so as real estate professionals, as real estate agents, as title companies, as lenders, as property owners yourselves, please realize that before you sign a contract, which is very easy these days with DocuSign, I see people getting very excited and just clicking through the DocuSign, not really reading it, not really understanding the significance of it. But really make sure that you are emphasizing and explaining to your clients that this is a legally binding contract. If you sign it, here are your obligations. If you fail to meet those obligations, there are some serious consequences that could come upon you. And so really think this through and make sure that it is what you are signing up for. So with kind of clients signing contracts almost willy-nilly these days, for lack of a better term, comes a lot of escrow disputes. So typically in a real estate purchase contract, one of the first things that happen is the buyer puts a deposit into an escrow account with the title company, or with the lawyer's office if it's a closing attorney that is handling the transaction. And so when that contract fails, when that contract does not make it to closing, we have to determine what happens with that buyer's escrow deposit. Does it get returned to the buyer, or does it get released to the seller? The contract is extremely clear about which party gets the escrow deposit under which circumstances. And again, this is a portion of the contract that I don't think many people read. I don't think many people understand. When you're signing a contract, you're not thinking what's going to happen if this deal blows up, because you're not thinking the deal is going to blow up. And usually it doesn't. But when it does, it is very important to understand what happens to that deposit if the deal doesn't close. And so a lot of times I get people coming into my office saying, well, I want to file a lawsuit for this deposit. Like I said, the contract is very black and white about who gets the deposit and when. There are not many things in the legal world that are black and white, but this one is in fact one of them. And so my answer is usually very clear to them. Either you are or you are not entitled to that deposit. And what are the options either way? There are times when there are unique circumstances that make it arguable that either party could be entitled to that deposit. But for the most part, it's a black and white issue. So what we need to look at in determining whether this is something worth fighting for or not is, number one, what is the amount of the deposit? If it's a $1,000 deposit, if it's a $4,500 deposit even, we really need to think about, and this goes back to the fees and what it's going to cost you to pursue something, whether that's a monetary amount that is worth it to you to pursue. If I quote you $5,000 for your case and you're chasing after a $2,500 security deposit, escrow deposit, that's probably not going to be a wise financial decision. I do get clients that want to pursue things based on principle and they don't care about what the numbers work out to, and that's a different scenario. But generally, most people want to do what's going to have the best financial outcome for them. And so the first thing we need to look at is the amount of the deposit and whether it's financially worth fighting. Usually it's not. That is because our court system and the litigation system, including attorney's fees, is pretty darn expensive. And so when you look at what it's going to cost you to get there, that usually rules out a lot of these types of cases, because the dollar amount that we're talking about usually isn't that large in comparison to what it could cost you. So that's the first thing that we need to look at. The second thing that we need to look at or consider is the process. So what happens when an escrow dispute arises? And I'm going to address this question based on the standard FAR contracts that are most commonly used in real estate transactions here in Florida. Of course, you can have other customized contracts and the answer would be different, but I'm going to answer it based on the standard contracts. So once an escrow dispute arises, the parties have to wait a period of time before they can do anything. And I like to describe this kind of as a cooling off period. So, these people backed out of the contract and I'm heated about it and I want to go after them for everything they have. That's usually the first reaction when something comes up. So we have this cooling off period, and the purpose of it is for, number one, cooling off, but number two, for the parties to get together and try to resolve this on their own without incurring significant fees. So we have this mandatory waiting period. That's step number one. Step number two is going to be mediation. So the standard contract requires that both parties attend a mediation in front of a neutral mediator before they can file a lawsuit for this escrow deposit. Again, the theme here is let's encourage people, let's try to force people even to work this out before they resort to spending tons of money on lawyers and courts and going through that litigation process. If the parties attend mediation and it is unsuccessful, the next step would be to file a lawsuit. And from that point, you would follow the normal course that any civil lawsuit would follow. So those are kind of the three major steps in determining whether this is something that I want to pursue or not. In the vast majority of cases, my advice to clients is, let's work this out. Even though this is a black and white issue, and even though it's my legal opinion that you, client, are entitled to this deposit, and if we're in a courtroom in front of a judge right now, I am very confident I could convince that judge that you should get the deposit. It is usually not worth the time and the money that it's going to take us to get to that point. So let's try to compromise, let's try to work this out. It's much better for you to split a deposit. Let's say it's a $5,000 deposit and we split it 50-50. So you're walking away with $2,500. Number one, that's a guaranteed result. Number two, that's a result that you have right now. That is usually going to be a better outcome than paying thousands of dollars in court fees and attorney's fees, going 6 months, 8 months, a year in litigation, stressed out, missing work, giving depositions, showing up in court. That is a very stressful, very lengthy process. Taking a $2,500 cut on day one and being done with it is usually the best outcome. Now, of course, there are situations where it is worth it, and that usually comes when we're talking about higher dollar amounts. I would say the bottom line threshold for that is going to be the $10,000 mark, and that is still low considering the costs that could be incurred in pursuing this in our legal system. So that is a very bird's eye view of an escrow dispute. I am seeing a huge uptick in them right now. I think that's number one, due to the increased market activity that we're seeing, but number two, I think that is a result of our very, very hot sellers market. And our sellers may be getting a little bit too confident, a little bit greedy, and wanting more and more and more, because this market has shown them they can get more and more and more. But that is leading, in my opinion, to an uptick in these escrow disputes. So if you ever have specific questions about escrow disputes or anything else for that matter, leave a comment. You can contact the firm at any time. That's what we're here for. But I did want to address that because this market is creating a lot of, I guess, unique and a lot of more volume of legal disputes that I'm seeing, and this is definitely one area that I am seeing it. So I wanted to address that for you. I slotted these legal lounge sessions for 30 minutes, so we are coming up on the end of that time. I do want to thank all of you for attending. Again, if you want to leave your contact information in the chat, that would be great. You can contact us. All of our contact information is on our Facebook page. You can contact us through social media, phone, website, email. We try to be present in all of the different areas that are available to us, but we are always happy to address any questions you may have. If you want to send me questions beforehand in an email, if you don't feel comfortable in the chat, I would be happy to address those next week. I will be here, same place, same time next week. I will absolutely be on time next week because now I know how to use Facebook Live at 12 o'clock for the Martinez Law Legal Lounge. Thank you so much again for attending, and I look forward to seeing you all next week.